Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Once again, my co-host, Jesse Barrientes. Jesse, how are you, sir?
I'm doing great, Dave. How about yourself?
Doing fantastic.
Excellent. Welcome to the fall.
You got it. Divorce and family law. Hate to break you the bad news, but it still exists.
Oh, it sure does.
Let's jump right in.
Well,
Jesse,
let's jump.
We
You know
have
what?
a new
Let's
code.
Let's talk. The law has changed so very much. Let's actually talk about some procedural aspects, not procedure for the law, but just procedure in terms of the filing. So
You bet. So the modernization.
modernization. That's
Yeah.
exactly right. So everything appears to be going electronic, which I mean, good, bad, and different. I don't know. I still like things the old ways. But what
You
happens?
want to wait at the courthouse, deal with the clerk
Well,
who's
that way I
angry.
want to send a letter, but not at 50 cents a postage now. But so what happens is now everything has to be filed electronically, and so that means and that's not just for divorce, that's for everything else too. So it has to be signed or digital signature and then scanned in, and then electronically filed, and there are different places. A lot of people use Odyssey, and it depends on which county and all that stuff you're in, but there's other providers, but that I think is one of the most common ones.
Yes.
And then it has to be hooked up with either a bank account for an e-check or for credit card. For things, if you're filing a new case, obviously there's a cost. If you're using a credit card, depending upon the jurisdiction, and they'll all charge you extra, it just depends on what they charge for that convenience fee.
Even though less clerks are actually required because you're doing the filing,
Right.
the costs have not gone down, they've gone up.
The costs have gone up. And,
Counterintuitive.
Well, the clerk also has to, obviously there has to be a file, so whatever you file has to be printed off in any event. And the old way we used to do is to either mail it in or go into the clerk. It would get file stamped. They would keep the original copy. You'd have your other copies and kind of go on your way. So that's really all done, except they do have exemptions for that. You can apply for an exemption from the e-filing. They realize that there might be some old-timers or even maybe not so old-timers that don't have access or don't really use a computer, and so they can get that waived.
Certain courts, there's no exemption.
Well,
Bankruptcy court, and if an attorney
bankruptcy
files
court.
something non-electronic,
Right.
they're going to have to come into court and explain why they should not be held in contempt.
The state courts allow you you have that exemption.
Okay, good news, bad news.
Yeah.
You can file 24/7. The bad news, you have to wait for approval when you file something, and sometimes that takes days, up to
Well,
a
I'll tell you,
week.
I'm not going to mention the county, okay, because I practice in multiple counties, and sometimes it takes a ridiculous amount of time. The problem is, well, it's not a problem. So basically, if you file
it's a problem when you're trying to set a motion date.
If you file it on a Saturday or a Sunday, all right, it will. The date, once it gets approved, will be the first regular, so it would be the Monday, as long as it's not a holiday. If you file it on Friday and at 4 o'clock, and it will get that date in terms of filing once it becomes approved. Now, it can be rejected, and recently I just had it was a garnishment, so post-judgment collection for fees, and they rejected it.
Why?
Well, they did it improperly. I used their forms, and again, I'm not going to say the county, and it was their forms, and they said, oh, you didn't have the date or courtroom on there, and I said, it's right there. I had to talk to a supervisor, but I had waited like a ridiculous amount. I had waited like 5 or 6 days for that, and it's like, oh, no, you have a certain amount of time, 7 to 21 days or whatever.
For the return date?
To have it within that time that it has to be issued. And so it's like, oh, no, I'm not going to resubmit it and wait another, 6 days. So that got resolved. But anyway, so it could be rejected for a lot of different reasons. And then it obviously gets paid for, and if it gets rejected and it was a pay thing, obviously you get refunded, but you'll obviously have to pay it. So that's the way that kind of works. It can get a little more complicated.
Generally for practitioners, for their office staff?
I can tell you what it means for me.
Sure.
It's I do most of my own work, and I will tell you that it's difficult because you file it, okay, then you get an email. If I file 5 things on the same case, I get 5 different emails that says, okay, filing submitted for this, for that, for whatever. Okay, and I'm a paper kind of guy, so I copy those to prove that, hey, that's when it was submitted.
Yeah.
I also save them in a PDF on an electronic file. And then whenever it gets approved, I get 5 more or how many ever more emails that said filing approved.
Right.
Or
But
accepted.
then you get the actual document
Well,
that
right,
has
filing
the file
accepted.
stamp on it.
Right,
So that's
then
your
you get
proof, too.
that, and you have that too. But so you have to go through all that, and it takes time. So it's an extra step to be able to do those kinds of things. And
So it's hurting your client then because you're billing for that
well,
time frame.
it's time. It's another thing, and that's something. Again, you just used to send it in, and there you go. And there wasn't much of an issue. But that's kind of how things are going. And so you have to do that with everything now. And so we were talking about divorce. So that happens a lot with divorce. You mentioned too in terms of getting a date. So
Yes.
it
Emergency
depends.
motions and things
Well,
like that.
emergency motions. I'll tell you because I've done several of those. So it depends upon the county.
Some are even an emergency.
Actually, they all were an emergency,
Sure,
Dave. Every
sure.
one I did was I didn't just
Not
do that
not
to
every
get in.
practitioner follows that, though.
That's true. They just do that to get in before the court because
And
the
then the
date's
judge
not available.
chastises them.
Well, again, it depends upon where you're at and who the judge is. So different counties have different things. Some counties you call in to get a date.
Well, let me ask you this. Is failure to provide visitation, is that an emergency?
A failure to provide, no.
Okay.
What's an emergency is, hey, look, there's been an outcry. My children have been abused by the step children,
Allegedly.
or guardian ad litem comes in, or hey, guess what? My ex or my wife is getting on a plane to Mexico or Canada or wherever, and without my permission. That's an emergency.
Okay.
A lot of people, some judges think everything's an emergency. Some judges think nothing's an emergency, and some judges will go in between there.
Yeah, I err on the non-emergency side.
Well,
on
but
most
if
things.
it regards the kids, a lot of times they're going to err on the better side of caution, which is to, hey, okay, look, you know what, we can sort it out. But again, first you have to prove that threshold. But the whole point is in terms of getting a date. In certain counties, you can call and get a date and schedule it, and then you put it in because it allows you, when you file it electronically, to put a comment in to whatever clerk is going to look at it, and you would simply say, hey, look, it's this date was approved by the scheduler, so that they know, and then so you shouldn't have an issue with that. Some places require you to go online, or some counties online, to see what's available for that particular judge, and then that's what you have to put in, whatever date that is. And then other places like, other counties I'm not going to mention, and it's not a really good system. So after you filed everything, you have an option to schedule it, but it pops up only after it's been filed to see what date it is, and there's a certain way to do it so that
Talking
that
about a very large
happens.
county?
I may be, and and then to get that date, then that goes in. Emergency motions are different. So emergency motions, you don't schedule that particular date. What you do is you have your emergency motion, and sometimes, depending, I will call the judge's clerk to see, because if we have a guardian ad litem involved and they're not available at the normal motion time, to see if, hey, look, can we do it a little later? I know I've done them at 11 or even at 1:30, based upon that, and with the clerk's, the judge's clerk, with that, with their blessing. So you just file it, and then you bring it in, and a lot of times you have to go down to the clerk's office to request the file be sent to whichever courtroom that you're in to be able to do that. So that's another hassle in terms of getting times, but it depends on what county you're in. So
A lot of complexity then. The different counties have different procedures, different filing systems, different dates. You really have to stay on your toes. And what if you're practicing in multiple areas and you're doing a real estate closing and you do criminal law and here you're doing a divorce case, let's say in Lake County.
right.
You have to be on top of everything, otherwise you're on the hook for malpractice.
Well, but that's why you get an attorney who's on top of everything, Dave. Okay, and it's not that difficult. Hey, look, there's a point at which you've got to you have too much work, and somebody needs to hire somebody. But it depends on what you're really doing. I wanted to hit one more thing. We might have talked about this on another show, which was the state-approved forms. I think we might have mentioned that one time before.
Let's talk about it. It's very important.
So they have on the Illinois website, state of Illinois, there's a link, I'm sure, to these approved websites or approved forms that are approved in every county.
And this was the legislature that made this available.
The legislature that made it available, and it's
For what purpose?
well, for access to justice. There's a lot of people who don't have a lot of money, and so even though there's Prairie State Legal Services and there are pro bono attorneys and there are different programs and different things going on for people, people just don't have the access. And so it's tried to make it easy for them to be able to put a petition for dissolution, for example, together. The problem, though, and I'll tell you what, those forms are good and they're bad.
Does this translate to hospitals?
I don't know, Dave. It could.
Have your own procedure?
Your own
Do it yourself?
Well, the problem is this. I mean, again, if you don't have the
Do
money,
your own exam?
if you don't have the money, you don't have the money. I understand that. However, if that's the case, there shouldn't be a whole lot of complication. But I will tell you that those forms are dangerous because, number one, they are not that comprehensive.
And they don't accomplish it all.
And they don't accomplish it
They
all.
don't.
And they leave a lot of things. So what's going to happen is, if you can afford an attorney, you should hire one. If you do it yourself, then what's going to happen is there's going to be a problem because you're not an attorney. I can't presume to go and be a mechanic and or to go to Fermilab and do one of their jobs. I have no clue how to do that.
That's my hospital example.
Right. So it's very important. But if you don't have the money and hey, you're clicking the boxes, the judge, a lot of counties now have just a judge that's dedicated to, well, they don't call them pro se people who represent themselves now. They call them self-representing litigants. So that's what they
People's
have,
court.
right? That they're dedicated
That's what's
to.
in the people's court.
Well, but they have that so that there's no attorneys. It's just people who are representing themselves, and the judge, generally extend a little more leeway in those situations. But
Relax the rules.
relax the rules. But those forms are what they are. That they give instructions. But if it's somebody, and I would tell you a recent example, and I won't tell you what county either. So they made a significant amount of money. The judge told them there was no children involved, but the judge told them, hey, look, you should have an attorney do it. No, they didn't want to. They did their own forms. And okay, fine. So, of course, I get hired to clean up the mess because things are ambiguous. And
Oh, the form didn't take care of everything?
no, it didn't. And so we went in there and we had
What happened?
filed all these things. And so when it was time for the hearing, for the trial on those post-decree things, the judge looked at both parties. He said, I remember when you were in here, you both make enough money. I told you to get an attorney to handle it and to take care of it. You didn't do it and you used those forms. I'm dismissing both of your petitions. And
But that's the same judge that signed the judgment utilizing those forms.
That is correct, but he doesn't have a choice. Those forms have to be accepted in the clerks and
Okay.
everything
So this
else.
is like a do-it-yourself kind of deal. We don't recommend that
It
in
is.
any
Don't
case.
recommend that. I mean, for anything. But if you can, hey, you need to try. And because there are also other attorneys who will, possibly even walk you through that or draft the documents for you without you having to hire them to go into court.
Yeah, there's samples online. They can go into the
Well, there's somebody,
library.
you're still doing the same thing. You still
can
got to
pull
know
old cases.
right? But you still need to know kind of what you're doing. So you can also, and I've done that for people in terms of, hey, just been retained to draft something or something of that nature. So that's important.
There's ICL books at the library that have examples if people want to be their own lawyer. I don't recommend it.
No, but hey, if you don't have the money, again, that is what that is. But again, the saying is, a person who represents himself has a fool for client, right? So let's talk about then. We're going to talk about divorce. All this kind of really applies to everything, and in terms of electronic filing, in terms of the exemption, in terms of
Welcome to 2020.
Welcome to 2020. I know, and now the thing is, everything is changing, and even some of the courtrooms will allow people to kind of phone in. And I don't know if we're
In the rural areas.
In the rural areas,
Not
but
in the metropolitan.
Even in here too, will allow somebody. Because sometimes you get a client or a party who is in a different state, and if they're not represented or if they need to be present for some reason or whatever, some of the judges will allow the telephone and they hook it up and it goes on the record and everything else too. But so that being said, now in terms of filing your petition and everything else, it depends whether or not you have children or not. If you do, things are more complicated in terms of the divorce process, because then you have to deal with the allocation of parental rights and responsibilities.
Yeah, let's get into some of the changes that the legislature made to kind of simplify things even for the attorneys. For example, let's talk about the grounds, the reason for the divorce. There used to be a myriad grounds.
Right.
Now there's one. Talk about that.
One is just irreconcilable differences, and Illinois has always been a no-fault state, but they had other like mental and physical cruelty, desertion,
Adultery. That was a big one.
adultery, habitual drunkenness. But
I want it on paper that
I
he
want
or
on
she
paper,
did that
right.
and the other.
And so irreconcilable differences, before it used to be you could allege that. Well, generally people would allege other things, but then they would, in the alternative, allege irreconcilable differences, because you had to have been separate and apart for a continuous period of time of
2 years, which is a long time.
All of that, except for 6 months, could be waived. And it doesn't necessarily physically living separate and apart. Sometimes they're in the same home, they're in a different bedroom, or even they might even be in the same bedroom, but they're no longer intimate. They're no longer living as husband and wife. They're just roommates.
Right. But under the current law now,
Right.
irreconcilable differences are the only grounds
Only
you can
grounds.
use, and it only requires a 6-month separation,
That's
not
correct.
functioning properly as husband and
That's
wife.
exactly right.
A very low threshold.
Right, very low. So that's
So the
all.
legislature finally gave in to this idea of trying to keep people together, and okay, you want the divorce, we're going to make it happen for you on an uncontested basis.
Well, irreconcilable differences requires an allegation that attempts at
nobody's fault.
reconciliation has tried.
There's no fault.
Well, basically, it's look here. We just
You
can't
want
get
it, you
along.
got it.
Well, perhaps if getting
and that's okay.
well, Dave, if getting married was as expensive as getting divorced, perhaps that might change.
No, I've been to some weddings. They're plenty expensive.
Okay, well, so are some of the divorces too.
Yeah.
But in any event, so the legislature. Let's talk about the legislature. That's a lot of attorneys. Well, as far as the grounds are, that's fine, because there was never an issue before. That really doesn't hurt anything. And now they've switched it. It used to be custody and visitation, and now it's the allocation of parental rights and responsibilities. But a rose by any other name is still a rose. And so we're going to be sticking with custody and visitation terms, although they're going to be referring to the allocation of parental rights and
hundreds of
responsibilities.
years.
Right. And that gets divided into 2 prongs, really: parenting time, formerly visitation and custody, and decision making. And those areas are religion, medical, schooling, and
Health,
extracurricular.
extracurricular.
Well, right, but the deal with that is that any one of those can be sole or joint or any combination thereof. It can be broken down for that. So that's kind of.
So we're not
changed.
fighting over custody, we're fighting over decision making.
We're really fighting over custody is what we're fighting over.
And we're not fighting over visitation, we're fighting over parenting time.
Right.
See, I'm just using the new words, but it's the same old.
Well, but we're using these
Just new
perhaps
grounds.
politically correct words, okay, because it's offensive to say
that
visitation.
gets us far.
It's offensive to say visitation, perhaps.
Why?
I don't know. I didn't say. That's perhaps some of the thought, as in terms of parenting time, to kind of tone it down a little bit. A lot of people are under the impression that, well, I lost my kids. I don't have custody. I lost all my rights. No, you didn't. Okay, so each case is separate, and
I'd like to think you're parenting even when you're not with your kid, and that you're actually, the teachings that you've given are with that child. So the parents is still with them, even though they're not, quote unquote, visiting.
Dave, that would certainly be the goal, but let's be honest, okay? There are a lot of kids who just, a lot of parents who kind of drop the ball on that one.
A lot of parents who don't exercise the visitation either.
That's
the
right.
parenting
They just kind of let that go. But you have again the situation to be nice co-parenting is a big thing. Mm-hmm. The problem is that people can't get along, and that's why you're getting divorced. However, they still, for the sake of their children, can't get along when the children are present. And a lot of times, they say horrible things about the other parent when they have their parenting time or their visitation.
Yeah. Well, oftentimes one of the reasons for the divorce is they can't agree on how to raise the children. So it begs the question, how's it going to change after a judge signs a document?
You're going to be back in the court for a lot of different reasons if that happens. But
with the forms.
Well, if you use the forms, then they're not going to be sufficient enough for
You're
you.
not going to pay for counsel, though.
No, certainly
Post
not.
decree is more expensive sometimes than the underlying case.
Depending upon what it is and where you're going. But, they've also changed the, let's talk about the two big things, too.
Yes. The money.
Let's talk about the money. Let's talk about
How does it work?
child support. So, before, child support.
Child financial allocation. Just kidding.
Well,
they still call it child support.
They do. So child support, well, actually, they call it
didn't-
something different. Okay, well, we'll get to that.
Okay.
So child support used to be based upon a percentage of the payor, the person who has the children the least amount of the time, based upon that person's net income. And then in the statute, they define what net income is, what comes out, and everything else. Okay. And depending upon how many children you had, one child, 20%, two children, 25%, and the percentage were different.
But it was a guideline that could be
There
varied.
was a guideline, and it could be varied. It could be deviated from upper, or lower. All right. So now, Illinois.
That's gone.
That's gone. Illinois has adopted income shares. See, I was going to say child support, income shares. And income shares are a little bit different. So basically, they take the total gross income of both parties. It gets added together, and then there is a table that the Illinois Department of Human Services has put out. And so you look on the table, and you see, okay, well, the income and the number of children, and you go down, and then you get what they call a standardized net income. Now, let me tell you the difference. Standardized, and that's what the law says. So you have to use standardized unless the parties agrees otherwise, or unless the court orders that. Those are generally and typically for huge income earners. So for the most part, people aren't going to, come across that. So they use the standard, whatever the chart says. And then different things get divided up. For example, let's just say there's a proportionate share. So maybe the payors, is at 75% of the money, and the payee is at 25%. So other things are going to get divided that way too. For example, insurance for the children. So whatever the premiums are, that gets taken into consideration. Now, one other thing that goes into the consideration for child support now that didn't happen before was the amount of overnights that a parent had. So once one parent has 146 overnights or more, that gets calculated into the equation for support. Now, a lot of attorneys use programs, and there are different calculators that you could probably look for online, but you really want to go to somebody who knows what they're doing. And then so you get what the amount of support is. And so that is really, like I said, based upon both parties' income. Before, it wasn't. Who cared, even though both parties had to provide information, it really didn't matter what this other person was making. Hey, you're making this amount of money, you're going to pay.
Cover those days again for the layman so they can understand how important that number is.
146 overnights. And if it's 146 overnights or more, that also gets calculated into the what the child support is going to be. Now, this law has had a lot of unintended consequences in every way. Some good things and some bad things. Some people are getting, zero. Some people are getting, still even a windfall. It just depends. But the bottom line, too, is the court, the judge, still has discretion to be able to adjust whatever they're going to do. So now...
It seems a little impersonal going off of this standardized sheet that you're talking about.
Well,
I would think that the judge would take into consideration a lot of other factors other than the number of overnights and the schedule.
Well, write your legislature, Dave. Okay? Because that's what the rules say now, and the judge has to follow the rules. So, well, I say that like they always do, but anyway, that's the gist of it. So the other thing, too, important to hit, as we covered on today's show, it's a little bit different than most. Again, the new procedure as it relates to the e-filing and all the other stuff, and so the money issues here and the change rather in terms of custody visitation, and then also the money issue. So we talk a little about child support. So now maintenance has changed too. So, well, maintenance has changed a couple times, Dave. Within probably, I think the last, I even
last
think
5 or 7 years.
last 5 years,
Yeah,
I think, right?
True.
So before it was again discretionary. So the judge had discretion.
Well, there were 16 different factors back in the
Well,
day.
and then there's the all catch and anything else that the judge wants to consider.
Right.
Okay, and so they would look at all that. And okay, and then it changed to they would take 30%. Actually, they would take the payor, who's going to pay 30% of that person's gross, minus 20% of the payee's gross, and then they would come up with a number, and then based upon how many years they lived together or were married, that would determine the duration. But the court still has discretion to be able to figure that out. And so when you're talking,
I'm sorry, this will disincentivize someone to work because that calculation is going to come into play 30 minus the 20 as opposed to 30 minus the 0. So you get
Right.
into that same to and fro on
Well-
should they be working, are they not working
Right.
what they could be working. So issues galore.
right, and we still have that. So I'll get to that in just a second if we have time. But that's the way the old law. And then it's changed again. And before
You
used-
choking up on this
I'm
maintenance
choking
thing?
up. I am choking up a little bit on the
Okay.
maintenance.
You
But
okay?
I'm not going to have to pay maintenance because I'm going to be
That's
married
right.
for the rest of my life.
Well, you hope. It takes two.
Yeah, it surely does. But before, you used to be able, for whoever's paying it, would be able to deduct it from their taxes, and the person who was receiving it had to include that in their income. And what that allowed to happen is that allowed for the payor to actually pay more because of the break that they got on taxes and all that was figured out.
Right. Uncle Sam's out of this now.
Right, so it's all done. So now it's 33 1/3% of the payor's net,
Okay. Good deal.
minus 25% of the payee's net. And then what happens is,
How long are they married?
well, yeah, and then you go through those calculations, and it's out in the statute, depending upon how long you're married, anywhere from less than 5 years to less than 7 to less than 20 to over 20 years. And the court still has discretion, but now it's no longer deductible by the payor on his income tax returns, and it's no longer includable in income by the person who is actually receiving it.
Yeah. Sounds like we need a CPA.
Well, not exactly, but pretty close. But the whole thing with this now, again, it's really different. And so now we're talking about child support and maintenance. So, well, guess what, Dave? Oh, we have to go and figure it out because if this person is getting child support, that gets factored into the equation with respect to the maintenance. And a lot of times judges will, if somebody's not making any kind of money, they will what they call impute income. In other words, that's basically saying, yeah, you're not making the money, but I'm going to, for the sake of the argument, you should be able to at least have a job making minimum wage, so we're going to impute $30,000 a year to you.
Wow. After all that, I got some advice for our
You
viewers.
do. Okay.
Stay together.
Yeah, that's
Thanks,
true.
Jesse. Good
You bet, Dave.
information. This has been Legal Action. We're talking about divorce and family law. Exciting stuff. We'll see you next time. Take care.